Welcome, everyone. It's 11:30, so we'll go ahead and get started. Thank you all for taking the time to be with us today. I'm Brandy Gray, Program Speaker Ambassador for MT Sherm, and I'm excited that you all will be with us as we discuss navigating U.S. immigration. So we'll spend this time discussing compliance, talent strategy, and risk management. Before we begin, let's go over a few housekeeping items. The chat feature is available if you have any questions throughout the webinar or throughout this session. As time permits, we will address questions throughout the session as well as save time at the end for those questions. If there are a lot of questions, we'll provide them to our presenters and we'll have her follow up with us. After the presentation is over, you'll receive a short survey via email. We use the data from that survey to ensure we continue to provide members with speakers and topics that are relevant. Also, a follow-up email will be sent to all attendees in a few days that will contain your CE credit information. I'll introduce our speakers and then I'll turn it over to them. Anna Scully is an immigration attorney for Burr and Foreman, our sponsors for today. Anna represents businesses, families, and individuals with the process of obtaining legal immigration status for key employees and loved ones. She interacts directly with the client at every stage of the process, from finding the right visa solutions and evaluating the strength of the case to dealing directly with the federal government while a case is under review. Anna lives in Mobile with her husband, William III, and enjoys fishing, cooking, and occasional game of billiards. Co-presenting with Anna today is Emily Mack, partner at Burr and Foreman. Emily is experienced at employment law, complex litigation matters, and has defended claims for wrongful discharge, retaliation, discrimination, harassment, wage and hour, business torts, trade secrets, and other complex matters arising from a variety of laws. She has also handled appeals at the state and federal levels and appeared before numerous state and federal agencies. She has considerable experience drafting employee contracts, non-competes, handbooks and policies, and providing in-depth training to clients. When away from the office, Emily enjoys spending time with her dogs and training for marathons. We're excited to have both Anna and Emily sharing with us today. So I'll pass it over to them.
Thank you, Brandy.
You're welcome.
All right. Well, welcome everyone today to this webinar. It's on a very valuable topic that I know very little about. Anna Scully is our expert here. She was kind enough to take her time to come and speak to you guys. And this is really intended to be a session that is for your benefit. I see we have 43 participants right now. That's great. We want this session to provide you with the answers to questions that you may have. This is an extremely hot topic, particularly in 2026. In fact, in Middle Tennessee, there are now some rumors circulating in the news the past 24 hours about an ICE detention center potentially opening in Lebanon. And so I don't think that there is a more timely, relevant topic right now. But I would encourage you to put any comments, questions you have in the chat feature so I can try to filter through those and get those questions to Anna. But we're just going to dive right in and make the most of this this hour that we have here together. So Anna, thanks so much for joining us. Can you tell me a little bit about what are the most common I-9 errors that you see during audits?
Okay. Well, let's start here. Let's talk a little bit about why we want to discuss I-9. I mean, I-9 audits didn't happen a lot over the last 4 years. We're still waiting for them to get really good and ramped up in the coming years. But I also think it's likely that whereas in the past, I-9 audits tended to be something of a revenue collection tool for the government, they will continue to be that, but they may also become more of an investigatory tool as well as ICE and related agencies work through their current mission, which is trying to track down and deport people who are not lawfully present or who are in violation of their status. Eventually, they will turn to employers to try to decide whether employers had anything to do with either the attraction of or the maintenance of people who came here illegally in the first place and wanted to stay for the benefit of employment. So that's why we kind of harp on I-9s, even though that's not really the huge hot topic, at least insofar as what we see in the news these days. In terms of errors that I commonly see, it's of interest to me that as time has gone on and more employers have started using electronic I-9 completion and uh, retaining systems, that, gone are the days when I used to spend a lot of time sitting around looking at paper forms and counting up the number of times people forgot to check a box or fill in a blank. Those systems tend to prevent that type of error, which is good for us because the regulatory system that decides how much money you owe in the context of an audit is really geared toward tallying up fines based on the number of those types of mistakes that you make. But one thing that I do see fairly frequently is common with systems that aren't developed strictly to be an I-9 tool. When we use systems like ADP, success factors, don't get me started on success factors, systems like that that are multifunctional, and I-9 is just sort of a part of it, they tend to be cumbersome for employers insofar as, I start an I-9 process, it gets mired in some kind of complication, whether it's a data point that needs to be filled in, or, I'm waiting for the employee to take some kind of action so I can finish up. And that generates timeliness violations.
Mm.
The rule with I-9 is okay, the day somebody starts work for pay, employee has to complete their part of the form on day one. And then employer has 3 business days to complete their review of the employee's documents to ensure that this person is who he says he is and is authorized to work, and then complete their part of the form. In electronic systems, the products on the market that are not as great at this process, they can lose files, they can do all sorts of things that can result in timeliness violations. Um,
I would suspect there that the liability still lies with the employer too, right? That
oh yeah,
software provider is not going to take responsibility in the contract for those violations, even though it
oh
may be
no,
their tool.
I know, and I imagine that when you sign on to use, there are all sorts of disclaimers and indemnity agreements we're signing that say you can't blame us if it goes wrong or if we don't give you timely tech support to unmuck whatever's going on with the system. So, all that to say, one of the things I encourage many of my clients to do right now, knowing that there's likely to be some emphasis on I-9 compliance in the coming years, is have a good hard look at your electronic system. For one thing, ICE puts out guidance that requires electronic systems to meet a number of benchmarks, the least of which is not the fact that these systems need to produce something called an audit trail, which shows, who's accessed the I-9 at what point in time and were they authorized, so on and so forth. And then the second thing I want employers to be aware of is, look, if the government serves you with notice that it wants to audit your I-9 compliance, you have all of 3 business days to spit out every I-9 form you have on file, plus any supporting documents, notes to the file, whatever goes along with it, and get that in the government's hands. And knowing that failure to do so may result in fines in and of itself. So it may not be a bad idea just to undergo a drill and figure
To,
out, okay, can I really get my forms out of this system if and when the time comes?
and taking a step back from that, because we kind of dove right in with the errors, how does an employer find themselves in a situation where they're facing an I-9 audit?
So
What
there are a
triggers
number of
that?
different, go ahead.
What triggers that was my question.
Okay. So I-9 audits can be conducted at random. That's sort of the threshold. If I'm ICE, I have the right to audit any employer's compliance, regardless of size, industry, what have you. But ICE tends to set policy goals with respect to certain areas of employment that it wants to delve into. And infrastructure, meaning, heavy construction, industries that help with municipal functions like waste management, airports, things of that nature, heavy transportation, and food service. They tend to focus a lot on that because, from their perspective, food processing, heavy construction, all of those things are critical infrastructure, and that's a security risk if we're not convinced that employees working in those areas are, in fact, authorized to be here. So policy sort of ratchets it up a level in terms of, okay, am I really vulnerable as, say, a mom and pop retail outfit? Yeah, under that policy, probably not. Beyond that, ICE can respond to tips from the general public, from people under an employer's roof, what have you. And if they think the tip is credible enough, that can also trigger an audit. If they get wind of certain employment practices, they get wind of complaints that there are a certain number of people working at this particular establishment who do not appear to be illegal. Those can generate audits as well.
So we could have a disgruntled employee who, whether that's, valid or not, subjects the employer to an awful lot of time and expense associated with undergoing one of these based on a tip.
Right. So something to be mindful of for sure.
Yeah.
But the
It, go ahead.
well, the one nice thing about I-9 audit is, we often think that that means there's going to be an army of armed agents descending on our premises to collect our forms. Very rarely is that the case. It tends to be one agent who comes to serve a subpoena. He then very quietly leaves, and then it's up to us to collect everything and respond accordingly.
Is this one of those situations where the company should call their lawyer if somebody shows up with a subpoena from ICE?
I would prefer that for a number of reasons. The primary one being, look, if particularly in this climate, if you are being audited for I-9 compliance, we need to entertain the possibility that there's some greater investigation at play here. This could be a preliminary test to see, are you a right target for larger scale enforcement action like a raid? So that's the first analysis I would want to conduct as counsel. And then second analysis would be, okay, just in the context of your I-9 compliance, how bad is it? What kind of penalties do we need to prepare ourselves for financially? And then is there any suggestion of a pattern or practice within your I-9 compliance that means that ICE would be suspicious of your hiring practices or your onboarding practices or any indicators you missed that somebody you thought was okay actually really isn't okay? Those are things that could lead to a larger scale investigation.
And what are I'm sure it ranges, but just to give people an idea of the severity of this, what type of penalties would employers be facing?
Okay. So typically fines are issued at two main levels. The highest level, which can get all the way up to 5,000 plus per violation, is if I am knowingly employing somebody without authorization. And that can come from the simple fact that we just don't have an I-9 on file. That can be construed as knowingly employing somebody without authorization because we just didn't bother to check. To, I have an I-9, but it's so bad, so badly completed, or the documents that I reviewed are so clearly fraudulent that that can be construed as knowingly employing without authorization. Other things that we tend to miss, like re-verifying employees whose work authorization is temporary, it expires periodically. That can lead to that level of violation. And that's just at level one. ICE tends to function, I guess, like OSHA in this respect. If this is your first audit, there's a lower schedule of penalties, but as more and more audits come at you and you are now a second time violator, even a third time violator, we get into the tens of thousands per violation.
It's an important distinction too, because as a lawyer, we typically connote knowing with actual knowledge. And so really what you're describing in terms of not having an I-9 on file could just be negligence, and which is typically a much lesser standard, but in this instance, it could amount to a knowing violation. In terms of so many workplaces now have on-site employees and remote employees, how is that being handled right now in 2026?
Okay. So we still have the option with respect to fully remote employees to solve this problem that's been a problem for a long time. The requirement for I-9 in the beginning is if I'm looking at an employee's documents, I must be physically putting my eyeballs directly on the document and on the employee to satisfy myself that the person in the photo ID is really the person standing in front of me. And in the last administration, one of the concessions that we carried over from COVID is we do have the ability to conduct that review remotely. That capability still exists. That's still an allowance within the regulations. And what's required of us is one, we have to be an E-Verify employer, meaning if we are onboarding remote or hybrid workers at a particular work site, all of those work sites handling that type of employee has to be enrolled in the system and we have to be in good standing. And then we have to conduct this very awkward video interaction with the employee, which means that I have the employee in front of me on a Zoom meeting. That employee has emailed me copies of his documents and he's kind of showing me his ID right here in the screen, so I can satisfy myself that that really is him.
Hmm.
Um, I think that that may be something that we keep around. There are some participants in this administration that are hostile to that allowance, but by and large, I think most of the people in charge understand that this is really something necessary for us to have to keep up
Hmm.
with I-9 compliance. Um, but in
Do you
terms of,
do you retain copies of those emails, the documents that were emailed to you in the I-9 file, just like you would if it was an in-person verification?
yes, in fact, as employers, we have the choice whether or not to retain copies of the documents that we review, but that choice actually goes away if we use the remote verification system. So even if you don't routinely keep copies of supporting documents, you do have to, at least in those instances, along with some other scenarios under E-Verify.
If you're not required to maintain the documents, is that something you recommend as a best practice?
That recommendation changes a lot, and I'll tell you why. Um, so previously, back when we were all doing our I-9s on paper, it was a really great thing to keep copies of your ID documents and other, list A, list B, list C documents on file. Because if I'm the employer completing section two and I forget to record a document expiration date or something silly like that, I could get fined for that unless that information is right there in the I-9 file and ICE can see it. Then they don't get to fine me for those small mistakes. Nowadays, with electronic systems that really don't let you make those errors, I have a competing concern, which is knowing that sometimes there are a lot of people who have a lot of convincing fraudulent documents out there. Am I now retaining evidence in my file of, bad ID documents that may be bad enough that ICE looks at it and says, you really thought that was a legitimate social security card,
It
did
could
you?
prove their case,
Yeah,
right? In some
exactly.
instances. And then you also worry about the data privacy concerns, right? If you do have a breach or something, then you have a bunch of PII, sensitive PII, social security cards, et cetera, that are out there that are potentially vulnerable, which isn't an immigration concern, but it's an employment concern, I imagine.
Oh, yeah. And yeah, that's a substantial concern. And if, your electronic storage system is not fairly close to the top of
Secure.
the line, yeah. I mean, that can definitely be an issue for a breach.
But if it's a remote employee and you're doing a remote verification, then you're going to be required to maintain that
Yes.
documentation. How do you balance that document verification process with avoiding discrimination claims?
I think consistency is the key, as it is in most things in employment law. And it gets a little tricky with hybrid employees as well. You know, typically, from ICE's perspective, if I have a hybrid employee who is capable of coming to the work site from time to time, there's no reason to default to a remote verification system for that employee.
Mhm.
So typically, if we want to avoid suspicion, the best thing to do is set up a policy up front. We will do remote verification under these circumstances. If said circumstances are not met, it will be done in person, provided we have the capabilities to do it. And if you stay consistent with that policy, even though there are going to be guys from time to time who forget their documents and it's so much easier to do this remotely, you avoid questions that may come up during an audit, such as how interesting you have this group of employees that didn't really fall in that policy, but you did remote verification anyway. Why is that? What were you trying to avoid? That's kind of the take that ICE you get from ICE in these situations.
Right, and that makes sense. What about best practices in terms of being unsure of or suspicious of a document's legitimacy?
Okay. This becomes more and more of an issue. And the one rule of thumb I want employers to be aware of is this. Look, despite the fact that there are some pretty obvious fraudulent documents out there, no government authority expects employers to be at the level of forensic document analysts. They understand that, there are not a lot of resources out there for you to be able to determine what's real and what's not.
Mm.
Um, so the best thing an employer can do is just stick to the documents in front of them. Clear from your mind any other external circumstance during that review, and just make sure that if you have concerns about legitimacy, it's based on the texture of the document, the quality of the photo contained in the document, the fact that this driver's license says that this person is 5'7", 150 pounds, but the person in front of me could have been a linebacker for the Seahawks at some point. If those are your only considerations, that protects you really from any con- real concerns about discrimination, as opposed to, hey, I've heard that there are a lot of fake green cards out there. So if this person is bringing me a green card and they look like somebody who might hold a green card, should I be a little more careful with this document than I would otherwise be?
Right, you kind of have to put any implicit bias aside and try to focus on the documents that are in front of you, almost in a vacuum, if you will.
Exactly.
All right. And in terms of, we have a good, I think a good question here from the audience about expanding on the relationship in the I-9 context between an employer and a contingent workforce agency, like a temp agency, as it pertains to the audit and responsibility for I-9 verification.
Okay. Let me read that real quick.
And I'm interpreting this as meaning kind of like who's responsible primarily, I suspect.
Okay. So if I have outsourced my I-9 compliance almost totally to an outside agency that's supposed to conduct all of that for me, like a labor source, a staffing agency, then that staffing agency has preliminary liability for everything that goes wrong with I-9. There are opportunities when ICE can look past that barrier if they get some kind of sense in the investigation that we had reason to know that all of the I-9 compliance problems that were going on in this temp agency were happening. For example, if I'm an employer who onboards people from a labor source, but I also do my own ID checks, maybe to say give badge access to premises. and I'm seeing a lot of bad IDs, potentially bad IDs in that process, then that can diminish that barrier or remove it in some cases, such that ICE can hold me just as accountable for the temp agency's I-9s as they will the temp agency.
Yeah, so we can't turn a blind eye then. But in a bona fide kind of, three-party relationship there, also that would be another area where typically we will address that through the contract, make sure that the obligation for I-9 verification runs with the temporary staffing agency. Also make sure that there can be some audit functions as well to kind of have that double check and make sure that you're, if ICE is trying to reach the worksite employer in that situation, that you have some protection there because you say, hey, we have this contract, they're responsible, we do audits to make sure that they're doing it in those situations, I assume.
Absolutely. And you know, you want those provisions in your contract, but you also want to be sure you don't go so far in the contract that you are requiring things that you aren't prepared to follow through on. Some of the worst cases of that kind of liability I've seen are employers who not only say you're responsible, but I will be checking up on your
Mm.
compliance. I want access to I-9s if I ask for them so I can ascertain whether or not I'm comfortable with your level of compliance. Well, of the 50 folks who are in here, I mean, how many of you have time to audit somebody else's I-9 compliance? You barely have time to audit your own. And if your temp agency were to get in trouble and that contract is in the government's hands and in their review they say, well, you gave yourself the right to look at this, why didn't you do it? Then that can really make an investigation difficult on your part.
Or you did it and there were issues and you should have known them, and so now you're responsible because you do know. So it's a very seems like a big gray area in a lot of
Exactly.
ways in terms of finding that right level of control in those situations. We have a few more good questions here in the comments. One about which version of the I-9 form should employers use, and which version do you recommend?
Okay. So versions change periodically. And your obligation as an employer is if ICE announces that we're publishing a new edition of Form I-9 and the deadline to start using it is this date, then everybody who's onboarded as of that date going forward, they have to be on that version of I-9. There are times when maybe we missed the announcement and we're still using the old version of I-9. Electronic systems are really good for catching changes like that. They will automatically be dumping you into that new version of I-9. To the extent that anybody's still on paper, note that it can be punishable by fines if you are using an old version of I-9 after a new one's been published. Um, there's also Spanish or different language versions of I-9. And sometimes those can be helpful. I tend not to like to use those very much because the current version of I-9 has lots of room to state whether or not you had a translator or interpreter present to support an employee with use of their part of Form I-9. Does that answer the question?
I think so. Yeah, I think so. Um, I wanted to touch on re-verification a little bit. What mistakes do you see there? Common mistakes that employers make when it comes to re-verification.
Okay. There are two main times when re-verification becomes an issue. All right. One is if the employee has temporary work authorization. We touched on that a minute ago. Anybody who is not a U.S. citizen or a lawful permanent resident, more likely than not, has expiring work authorization. And your obligation is to make sure that that employee has renewed work authorization on or before that expiration date to remain compliant. And you have to actually, you don't have to do the full document examination. You're usually just looking at a List C document to be sure that that work authorization is renewed. But that does have to be recorded in Form I-9. It used to be Section 3, now it's Supplement B, I think it is. The other time when reverification becomes an issue is if work authorization in any form that we thought was legitimate is called into question. We were talking about actual knowledge a minute ago. There's a step down from that known as constructive knowledge. And if we got time, I'll dwell on that for a minute because I think that's a fairly hot topic these days. Let's say I have a beautiful, fully complete I-9 in the file. I've reviewed documents for an employee. They appear really legitimate to me. And then I get a notice in the mail from Social Security that says, the withholdings you've been pouring into this account don't really match the information that we have on file for that person. Or the other one that tends to be a problem is I'm doing a 401k audit and my provider is sending me notice that, hey, all of these social security numbers aren't really matching up with the data that you're sending us about your beneficiaries. That has created constructive knowledge for me, potentially as an employer. And depending on the source of that notice, we take different actions. We have to review it on a case by case basis to see what we have to do. But reverification is often a part of that. If you have pretty clear questions, particularly from a government authority, that there might be a problem with this identity, then you are obligated to follow through on that. You need
Would
to address that with the employee directly. And then if there's no satisfactory obligation or satisfactory resolution to that encounter, then ultimately what you have to do is ask the employee to bring in something other than that suspect document and perform a reverification. And if they can't pass, that often leads to termination.
would that include like a child support garnishment or some type of wage garnishment where there's a mismatching social? I think I've encountered that before.
Right. If there's some question raised from a more local or state authority in that result, I think these days I would be more inclined to follow through on that than I might have been otherwise. But a lot of
So
times, what you can do is work with your employee to say, hey, there's some issue. You need to go to the government authority that's putting us on notice of this discrepancy to see if you can work something out. And a lot of times that gets resolved. And you can be reasonable and give your employee 15 days, 30 days, whatever the circumstances call for, as long as you are documenting each step that you're taking and updating your files with that so that if you are audited, you can show we were proactive, we did our due diligence, and we're in some process of trying to figure this out.
that's all great insight. We have a few more questions in here. One is pertains to J1 or other international employees. Is there anything that employers need to be aware of with respect to those types of authorizations?
There's been no real change to any of those visa programs to date, other than H-1B, and we'll talk about that later on if time permits. Um, so most of these programs have, limited periods of work authorization. And many of these programs also have other terms and conditions attached to them. So for instance, J1 interns, trainees, what have you, they need to be working in a capacity that is exposing them to some kind of knowledge exchange. They're not allowed to work cashiers at the cash register at a fast food restaurant. They're not supposed to be changing sheets at a hotel, things like that. They need to be involved in some aspect that's going to equip them with some skills that they can then take home and use in the next place that they reside. So none of those have really changed. None of those have really tightened up. We have seen from the individual perspective some additional scrutiny placed on the individual participants in those programs. And, that can become an unpleasant surprise for some employers if, you say you have a student on F1 or J1 working for you who's suddenly getting visa revocation notices in the mail. For our perspective as employers, there's really nothing that triggers liability for us in that circumstance, and really no obligation we have to participate in however that gets worked out unless government comes directly to us and says, hey, we don't like what this fellow's posting on Facebook. Do you know anything about that? Then we
Mhm.
would have the same obligation to participate in that investigation as we would any other.
And that's great insight. What about best practices for re-verification when DHS has provided an automatic extension with an expired document? Anything to
Oh
think
yeah,
about there?
those are super fun. Um, well, let's skip ahead to that topic because that really is a hot one. Okay, so there are a number of programs when we have an expiring work authorization, and we as the employer may be petitioning to renew it because we sponsor this employee, or the employee is participating in some other program that requires periodic renewal, or the employee participates in a humanitarian program that just automatically rolls and we don't get renewed proof of work authorization at the individual level. We get fun things like notices in the Federal Register that tells us all of these work cards are auto extended. So at present, a lot of the automatic extensions we relied on as employers have gone away. Let's start with one that a lot of our participants may be familiar with, F1 students and people who have work cards through green card processes, an EAD. DACA participants have these cards.
Hmm.
Um, there was a time when if I, as the employee, could prove that I timely filed to renew my card, and if it weren't for the extremely long processing times at the government, I would probably have the new card in hand on time. The government's concession for that is, well, based on that timely filing, we will consider that work card auto renewed for a certain period of time pending the receipt of the actual renewed card. There are only a few instances now where those auto renewals still exist. And that puts us in a tricky position because we often run into circumstances when an employee, they've gotten notice that the card's been approved, but the government just can't get it to them in the mail and the expiration date is tomorrow. What do we do? Um, the safest approach to that is to terminate with the option to rehire. Um, Particularly from a standpoint where we're trying to avoid the possibility of discrimination liability. It's best to have just a standing practice. If it's not here the day after your current card expires, we got to terminate, even if it's going to be a week or two. Now, we can make some carve outs in that. If we know the card's in the mail and it's going to be a week, maybe instead of straight termination, maybe we consider unpaid leave of absence, which allows us to continue benefits, continue seniority in the company. Yeah, that
Right.
can be useful for key employees. Um, but we also have to be careful when we avail ourselves of that option because if we use it for one person but not another, is that going to get us into hot water on a
Yeah.
discrimination claim?
The slippery slope there, that unpaid leave.
Hmm.
Yeah.
Now, the other thing that may be on a lot of our minds is uh, a benefit program called Temporary Protected Status, TPS. All right, TPS is available to countries that have suffered some kind of extreme political unrest or a natural disaster. The program exists because if we already have citizens of those countries here in the US, we don't necessarily want to force them to go back to that situation. We're going to let them linger on beyond the natural expiration of whatever program they used to get here in the first place. It has work authorization attached to it. And normally, if the time comes for the government to review that country's circumstances to see if we still need to be offering TPS, if the government decides it wants to do that, that's when we place a notice in the Federal Register that, that expired card this fellow's presenting you, it's actually still good. And you can just print this notice right off the internet and stick it in your I-9 file, contrary to all logic and reason, that's how we do things. Now, in our current climate, TPS has become really so difficult to manage effectively because this administration is trying to just terminate many of those TPS programs, sometimes ahead of the schedule that was set by the previous administration. And those decisions have been challenged through litigation in the courts. And we find ourselves in situations where we have one court saying, no, they can't terminate, everything's back to normal. And then the next higher court says, actually, no, they really can. And we're back to you're terminated. And that EAD or work card that this employee is presenting you is no longer good. Um, I have to think in regardless of how hostile this climate feels right now, there's going to be some forgiveness for employers when it's really difficult to know what the right answer is to whether a particular person can still work for us.
Mm.
I don't have anything to back that up legally at the moment, but the best thing employers can do in response to that constant oscillation back and forth is just to document what you're looking into and what you're doing to try to make sure that this person can still work for you.
Feels a little reminiscent of the OSHA ETS standard. It's on again, it's off again. What do we do? Well, as long as you're making good faith effort, there's got to be. You're not the only one in this boat, right? I mean, as an employer, other people are struggling with trying to understand the same rules and apply them in a way. Um, in terms of I mean, where do you want to go next, Anna, with some of these topics? Because I think these are all really important questions here, and I know we've kind of bounced around a little bit, but I want to make sure that we're hitting on the things that you think are kind of most critical.
It might not be a bad time to spend a few minutes on just worksite enforcement in general. It doesn't affect everybody equally, but I know it's on a lot of people's minds, so it's worth talking about the various ways that this can come up. Um, so we talked about I-9 audits, and my guess would be anybody participating right now, that's probably what you're most likely to experience as an employer. But we also have to be mindful that, yeah, there are a lot of higher level enforcement actions going on that have, large numbers of federal authorities from any number of agencies all showing up together to detain individuals or to investigate employers. It's happening here and there now. We see it happening predominantly in certain industries. Right now, ICE has a huge initiative to investigate construction sites. There are a lot of reasons for that, and I'll get into those a little bit. But construction, we see a lot of raids and investigations in the food service industry and in food processing right now.
Mm.
And we also see it in some manufacturing. Um, the thing that I want our clients to be aware of is that there are only a limited number of circumstances that actually allow any federal investigative authority onto your premises. And by and large, most raids don't really have that ability to access premises. When they do it, it's because we, as the employer, either knowingly or accidentally gave them consent
Consent.
to come in. So the two other main scenarios we see are these. Um, One is ICE will show up with maybe a group of 5 or 6 guys, and they present something called an order of removal or an administrative subpoena for an individual. The thing to remember about orders of removal is that, yes, this means that whoever is the subject of that order has been through an administrative court procedure, and the court has found that they can be removed from the United States. And the order is to ICE now to wherever you encounter this individual, you are to detain him and get him ready for the trip home. That order does not actually grant any authority for an ICE or other executing authority to enter private premises.
To get that person.
Exactly.
Big difference.
Yeah. Yeah. So let's say I'm a manufacturing company and I have somebody come into the front lobby with an order of removal. They say, we want to go back and get this guy. Okay. That creates a lot of difficulties for me as the employer. On the one side, I don't want to not cooperate. I don't want to be seen as obstructing the exercise of this authority or anything like that. On the other side of that, I don't necessarily want to give consent for law enforcement to enter places that they're not legally required to be. For one thing, letting five armed guys onto a production floor is probably going to cause a stampede, and I'm going to have any number of safety issues that I have to deal with. And I also, if they go back there and see something that creates liability for the company, if I've given consent to that, then that's evidence that they can use against me later on
Yeah.
if they want
Once
to
they're
go,
in, they're in.
they're
And
in.
yeah.
Now, the competing consideration is okay, I don't want ice back on my production floor, kitchen, whatever it happens to be. But I also know that they're not leaving until this person is in their custody. And if I go back and get employee and bring them to ICE myself, well, there are two things that could go wrong. If employee hears ICE is here and they want to see you, he may run away, she may run away. Then what do I go back and tell ICE? Uh, yep, they're gone now. Well, what's ICE's first thought? Oh, did you warn the employee that we were here? Did you instruct the employee to run away? Because that is the definition of obstruction under the regulations. And I also don't want to be seen as entrapping my employee because, if I just say, "Hey, can you come out here to the break room for a minute? I got something I want to talk to you about." They walk into the break room and there are five armed guys sitting there saying, "You're going to come with us." Do they have any recourse against the employer at that point?
And one question that comes to my mind, because this is triggering for me terms from law school, because obstruction, entrapment, those sound very much like criminal, terms. And so, are they, when these officers show up on a employer's premises, are they law enforcement? Are they something quasi administrative where they don't really have the same powers as a police officer? Or can you maybe explain a little bit about that, just in terms of where their source of authority comes from and what, how they should be treated? Um,
It's a very, very confusing gray area in that respect. But from our perspective, the best practice is even though I am executing what is arguably civil law, I do have the standard powers of law enforcement to do so. And I have the same access to Title 13 obstruction charges that I can levy against somebody who gets in my way. You know, ICE officer on a civil law mission can make an obstruction case just as much as an FBI agent, pursuing a kidnapping suspect. So I do have to be mindful that I'm, yes, in a very criminal territory in terms of can I be charged with obstruction? What rules say when and under what circumstances law enforcement can come into my private premises? We do very much exist in that world, despite the gray area over what immigration law actually is.
So, because of that, it would seem prudent to, again, involve the company's lawyer if someone is showing up, to make sure, and really to also avoid any kind of one-on-one interaction. I mean, you want a witness, you want to not be the only company representative that is interfacing with one of these agents or one of these situations, to be able to kind of, make sure, again, in the employment world, documentation is always key. So having, other people present to be able to say, no, they didn't tell, this individual to run out the back door, when we told him to come, he needed to, come to the front.
Right. I think the best practice is one, let's try to extract the employee from a situation where he could cause a larger, stampede from the situation. And then once we get him away from that immediate danger, away from the saws or the hot stove or whatever's in operation, hopefully in plain view of the ICE officers, we then tell him, hey, look, ICE is here. They want to see you. We don't know what's going to happen. And oh, by the way, whether or not you speak to them is your choice at this point. We don't say you have the right to remain silent. We don't say you don't have to talk to them if we don't want to. It's simply, it's your choice. And then we step back. That way we've protected ourselves and the company, but we've also not, just lured the employee right into the hands of law enforcement at that point.
Right. Because I imagine you could also run into, retention issues and culture issues as kind of backlash from that as well with other employees, feeling, yeah, in those situations. They are surely sensitive situations to say the least. Um, And so, by and large, though, the hope is that most employers aren't facing that type of, a raid situation or even having to deal with an order of removal. Um, but what should be included, I guess, in 2026, that's new in terms of, some type of ICE audit response plan? Is there anything that you would say has changed about the way that employers need to be preparing for these, for any type of enforcement action?
I would say that, having a dawn raid plan is never a bad idea because even when we don't have a direct document like an order of removal involved, that doesn't necessarily mean that ICE can't and won't visit certain premises just to see what happens. We are still very much in a situation with ICE where they've not been making cases over the last 4 years. They've been largely dormant. And, without cases to go to an actual judge and get a warrant to enter premises, sometimes the investigatory tool that we resort to is, well, let's just roll up on this construction site, rattle the gates, and see who runs away. And then that gives us a place to start with trying to figure out if we want to go after the employers, subcontractors, what have you. So my advice is, even just a rudimentary discussion of, okay, if law enforcement shows up on the premises, who's our point person? Who's going to deal with them? Who has the authority to give consent if we do decide that we want to allow them into premises? And the second thing is, let's also be very clear about which areas of our property are public areas and which areas are non-public areas. Do we have appropriate signage that says no, no one except authorized personnel beyond this point? Do our guard shacks and receptionists at the lobby have proper instructions for who to call and how to deal with people? I think it's never a bad idea to go ahead and at least start examining that frontline perspective.
I know that we're
Yeah.
coming up on the hour here, but are there any other topics or areas that you think are important to touch on before we wrap up?
I would love to gauge if anybody has any interest in the H-1B program. I think I made a promise earlier that we might try to talk a little bit about that. Um, do we have a hand raising capability where if people do have questions about that? Okay, we
Yep,
got a few.
I'm
Yeah,
seeing
there's
some
one. Yes,
votes.
please.
We'll take
Okay.
that.
Okay. So we've got two main changes this year. Aha.
Lots of hand raises.
All right. The first big change that everybody is very concerned about is the fact that if we want to sponsor an employee in H-1B visa status, we may have to pay $100,000 to do it, right? Um, we have actually walked pretty far back from that initial announcement last September. And it looks like $100,000 fee is going to be confined to situations where either my employee is outside of the US and is going to have to do certain things in order to trigger their H-1B approval and get back into the US, or even somebody who's here for various reasons cannot make this automatic change from their current visa status, whatever it may be, to H-1B without having to leave the country and come back. So let's say I have an F1 student. I love this guy. I want to sponsor him in the H-1B lottery. And he's been doing everything he's supposed to do as an F1 student. Immigration should have no problem just transitioning him from student status to H-1B without him leaving the country. No $100,000 fee attaches at that point. By contrast, if that student maybe didn't do the type of work that they were supposed to do, or before he got to us, has had some violation of his status, immigration may pick up on that in the course of looking at the H-1B application and say, okay, well, he can have an H-1B. He just has to go outside the US to get vetted before he can come back and really start working in H-1B status. At that point, when he gets outside the US, that's when government is going to demand proof that we've paid this $100,000 fee. So that's kind of the quick and dirty summary of that aspect. Other aspect is, for people who've never held an H-1B visa before, they have to go through a process that makes them count it against the cap. All right, so we have a statutory cap on the number of people who can have H-1B visas every year. And to manage the fact that we have probably 20 times more applicants than we have visas available, we have an annual lottery, which used to be just a random lottery. Everybody gets poured into a hat. We draw out 85,000 people. Those are the people who have their cases for visas adjudicated this year. This year, we're putting a little spin on it because we want to try to skew that selection to benefit employers who are paying higher salaries across the board. So prior to this year's lottery, we're all going through a very in-depth analysis to see how we prove to immigration that in this lottery system, I am paying a higher scale of salary to this employee, or that salary will be effective once he gets his H-1B, which gives my employee more shots at the lottery. Instead of buying one raffle ticket, if I can get high enough in that wage scale, I'm buying up to four for that employee to throw in and see if he gets selected. Um, there are a number of traps that you have to be mindful of. And I want to remind everybody that last September, Department of Labor announced something called Project Firewall, which is all about its efforts to really enforce its part of the H-1B compliance regime. And we're going to be paying a lot of attention to things like, well, you said your employee was going to make a salary at this level in the lottery, but in actual practice, he's making much lower. So maybe you owe some back wages, and maybe you're going to be barred from using the H-1B program ever again. In 50 seconds, I think the best advice I can give you is lottery opens on March 4th. Work with counsel if you've never done it before this year, just to make sure you're running the analysis and really thinking ahead to whatever you're doing in the lottery is going to play out when you get to petitioning. And be conservative this year, because this is the first year any of us have ever done this. We have no idea how this is going to play out in the future, but just be mindful that your choices we're making today, even if they're good for our employee, may be bad for us as employers in the future. That's all. I'm going to hush now.
Yeah, there's really not much going on in this area of the law. It doesn't seem like not much at all. Nothing to worry about, nothing to keep you awake at night. Well, Anna, thank you so much for spending your time with us this morning. I have more questions now than I even knew. But I'm
Rats.
grateful to have you on our team and grateful that you were able to spend some time with us this morning. So thank you.
Yes, thank you, Anna, and thank you, Emily, for being with us. And thank you to the attendees. Thank you for your participation, and thank you for spending time with us. Just a reminder, you will get an email, two emails. One email will have a survey. Please, please, please take the survey so that we can continue to give you these relevant speakers and relevant topics. And also, the second email will be information regarding your CE credit. So check out mtsherm.org to see our upcoming events. And we thank you all. Have a wonderful rest of the day.
Mhm. Thank you.
Thank you.
Thanks,
Bye-bye, you
everybody.
all.